We have either party on that matter present.
I'm here. I'm Jill Reno.
Thank you. All right. Is Mr. Boges present? It's not appear that he's in the court's Zoom room. In front of the court, what is the status of this matter?
The defendant was arrested on March 11th on a bench warrant for failure to appear at a hearing on May 17th, 2003. The defendant stipulated to making a payment of at least $300 by today and submit medical documentation of his inability to work full time. There has been no payment or information received. The defendant has a support obligation of $262 and a balance of $6,559.07. The last payment that was received was in September of 2023 in the amount of $62.94.
Thank you. Ms. Reno, any questions that you have or any comments that you would like to make?
Yeah, I do have a couple comments. That same day, last time he was in court, later that afternoon, he, and I have recording of this, he was in front of Judge Cooper for a different matter. He proceeded to tell Judge Cooper that he had just gotten a new job at a construction company. And I called friend of the court and I let my case note worker know, because just hours earlier, he had been in front of you, I believe, and lied and said he was unable to work. And then hours later told Judge Cooper he got a new job at a construction company. Again, which I have recording of him being in court telling Judge Cooper this. James, this is James. He's a habitual liar. This is what he does. Like, he will tell you guys that he's unable to work, that he's trying to get disability. He has been saying this for 20 years. Disability keeps denying him because he's fully capable of working. He makes a joke about how gullible you guys are and how you actually believe him and he can get away with lying to you. And it's not like the judge in West Branch, because the judge in West Branch, where he's got other child support orders for his other kids, knows that he's lying and, you know, knows that he's capable of working. So he laughs at the court system in Otsego County because you guys actually believe that he's not able to work and you just keep allowing him to do this. He hasn't paid money in forever and he just keeps getting away with it. And it's not fair. It's not fair at all.
All right. Well, looking at the file, I don't see where his support's ever been stopped or abated. So I don't think anyone's made a ruling that he's unable to work. But given his failure to appear today, I will recommend the issuance of a bench warrant. I would recommend an amount of $2,500 plus $100 in costs. You have any questions, ma'am?
No, I appreciate it. Thank you. Bye-bye.
Yes, Your Honor.
Yes, Your Honor.
All right. So both parties are present. In front of the court, what is the status of this matter?
The plaintiff has a support obligation of $121 and a balance of $810. A payment of $77.76 was received from an income withholding this month. Prior to this payment, $175.19 was received in October of 2023 from a previous income withholding order. Since a recent payment has been received from an income withholding, the front of the court would request the hearing be adjourned to June 12th in front of Your Honor to monitor that payments continue to meet the support obligation.
Thank you. Mr. Johnson, anything that you would like to say, sir?
No, Your Honor.
All right. So it is accurate that you are currently working?
I was just let go because my transmission went out in my vehicle.
All right. Well, that'd be important to share. So we're not going to get any additional payments then through an income withholding order. Is that correct?
There should be at least one more coming.
All right. And then where are you at then in the process of getting new employment?
I am going, give me just a second here. I'm stumbling on my words. So I apologize. I'm working on drawing unemployment right now. I'm going to Michigan Works later today. I have an appointment to help me with filling out my paperwork, and then they're going to help me redo my resume. And then I'm actively seeking employment. It's not like I'm not trying to find work.
Okay. Miss Perry, do you have anything that you'd like to say or any questions that you have?
I wanted to request that child support be increased when he does end up with employment. You know, I'm a struggling single mom, and Colton, the child, is growing rapidly, and I'm constantly buying new things, such as clothes. I struggled during the winter to pay bills because my hours were lowered at the time because it's always harder in the winter, especially with my job. It's hard when clients get sick because then I don't have work.
Okay. Well, certainly, depending on what his next job is, then the issue of support would be potentially looked at, depending on if there's a change in his income. But for today's purposes, I am going to adjourn the matter to June 12th. So obviously, sir, if you have any changes in you get employment, you need to make sure you let your caseworker know right away. If you start collecting unemployment, you also need to make sure that you let your caseworker know.
Absolutely.
So we'll adjourn this matter to June 12th to see where we're at with the new employment and go from there. Thank you both for appearing. That does conclude the matter party on that matter.
Yes, Your Honor.
Thank you. All right, both parties are present in front of the court. What is the status of this matter?
The defendant has a support obligation of $660 and a balance of $8,822. The defendant contacted the office yesterday with support concerns and options were discussed. His father made a payment of $1,000 by card that is still pending disbursement. This has been the only payment since the order entered in November of 2023. The friend of the court had contact on February 5th to address non-payment. At that time, he indicated he is currently in rehab and had not been working since December 17th. I confirmed his address and made him aware that the friend of the court would be mailing paperwork in a physician form regarding his inability to work and requested these forms be completed and returned by February 26th. The requested paperwork has not been returned. During contact yesterday, he indicated he is now in a sober living facility. I attempted to fax the forms, but he did not receive them.
Thank you. Mr. Brown, what would you like to say regarding this matter?
So what's going on right now is I have been in and out of rehab. I went ahead and finished all of those classes, and now I'm in a sober living. My work is not what it used to be. I'm only doing half part-time right now. I did, as she said, paid $1,000 yesterday, and once I'm getting back on my feet here, I have every intention to fulfill what I need to fulfill here. But at,
so you're currently
I'm sorry,
you are currently working part-time?
Yes, sir, I am.
All right. So you are able to make some payments moving forward, is that correct?
Yes, sir, I am. I definitely cannot swing the 600 as you guys want me, though, because my bills are quite expensive in this clean and sober living facility, and I have to pay for medication, and I'm 50 miles away from my shop, so I have to drive 50 miles in every day. So yeah, if I could get a lower payment, that would be amazing. But I do have every intention in fulfilling what I'm supposed to here.
All right. If you wanted to lower your payment, you would have to file a motion. If you are for some reason unable to work, it can be addressed. Typically, dealing with a substance issue doesn't render you under the child support guidelines unable to work, but you are free to file a motion to see if there is any change that could be made. Ms. Radke, anything that you would like to say or any questions that you have?
Some proof of him living in a sober facility would be helpful, because I recognize he's sitting in his father's house right now, which is 10 minutes away from his job. So he's a pathological liar, and I don't believe anything he says. He hasn't participated in his Zoom calls since October 19th. And he's continuously creating social media profiles to stalk me online. I don't believe a word he says. And I think him not participating in at least the 2 Zoom calls a week confirms that he doesn't believe he should follow a court order.
Thank you, ma'am. All right. So given that there was a recent payment, well, it's pending, it's not officially cleared yet, but given that recent payment, I will adjourn this matter out a little bit to follow up with additional payments. If that payment had not been made, I certainly would be considering a finding of contempt instead, but the information is there was a $1,000 payment that is going through the process right now. I'm going to adjourn this matter to May 1st to monitor what is paid in April, as well as an update as to the return to status. Again, I'm not making any decisions on a lower amount. There's not a motion before me to address that. Do you have any questions, Mr. Brown?
I do not, but I do have a statement. She, for some
That's
reason,
okay. We don't need to get back and forth. We're here on a support issue. We don't
Your Honor,
need to let you air your grievances together. Yes, ma'am.
could we confirm who the employer is and if he's able to update his address? Because he did indicate that he's not residing where we have his records as indicating.
All right. So where should your mail go to, Mr. Brown?
I have it going to my father's house, but if you'd like it to go to my clean and sober facility, I could definitely give you the address for that.
Well, how long do you plan to be there?
For right now, I'm thinking about staying here for at least another year. It's a very good facility. They keep me accountable. I get to go to meetings on a daily basis. It's helping a lot with my journey here.
I'll look to you as to where you think the best place is for your mail to go. So would you rather keep it going to your father's or would you rather go in there?
Yeah, going to my father's is just fine.
Okay. And then has your employment changed or you're just working less hours?
I'm just working a lot less hours.
All right. But you still have the same employer?
Yes, I do, sir.
Okay. All right.
Lot less
Any other questions?
No.
All right. Thank you both for appearing. We'll be back here May 1st to get an update. Thank you.
Thank you.
Mr. Kukabo, can you hear me?
Hello?
All right. Yes, sir. Are you Devin Kukabo?
Yeah, I had a problem with my muting on my phone. I tried everything. I had to recall. So
It's okay. We got you now. So we'll move forward. Front of the court, what is the status of this matter?
The defendant has a support obligation of $155 and a balance of $2,925.42. The last payment that was received was from a prior income withholding order in August of 2023 in the amount of $144. The front of the court would first like to know if the defendant is employed and for the defendant to submit a change in personal information form because we've received recently returned documents and contact information as well.
Thank you. All right. Mr. Kukaba, are you currently working?
I start Friday, my new job. I just recently moved back up here from what she was saying, my old address from Kalamazoo. I moved back up here just last night. So I'll be.
What is your new?
What was that?
What's your new job?
I'll be working at Tom's Supermarket.
What's the name of that?
Tom's Supermarket.
Okay. Thank you. And are you able then to contact the front of the court and provide your new address and contact information?
Correct. I can do it right after this.
All right. So given that you are starting a job, I'm going to adjourn your matter out a little bit to allow a income withholding order to be considered and processed, as well as to make sure that you do provide that updated information. I'll adjourn your matter to May 22nd.
Alrighty, sounds good. Like I said, I'll get that done right after this call.
Thank you. Front of the court, anything additional on this?
No, if he could also then just maybe leave a message and I'll follow up with him because I don't know if I'll be available shortly.
Okay.
If he can call, yes.
All right. Yeah. Make sure you provide your updated phone number as well as your address, and then your caseworker will likely be in contact with you. Thank you. By the party on that matter present.
Yes. Mr. Sala.
Right, good morning, Mr. Sala. Front of the court, what is the status of this?
Your Honor, the defendant has an arrears only obligation. We're on arrears of $50 a month. Current balance on the account is $10,709.52. Last payment received was in April of 2022 in the amount of $256.20. I did have contact with the defendant and he informed me of a personal matter that he had been tending to. And we are requesting that we increase the order of arrears to $200 a month, which is closer to the 2% total owed.
Thank you. Mr. Sala, anything that you would like to say?
I agree with the terms, and I have been in contact with Ruth and the kids. And when Aiden turned 18, I had received a letter when Sierra turned 18 stating that I didn't have to pay any more on her. So I did assume when Aiden turned 18, I never received anything else. And that is the month after that, I stopped paying. I have still been helping with the kids in Sierra, mostly Sierra, because Aiden works and he's You know, he does his own thing. I gave Sierra a $5,000 check before she was 18 for her first car. I paid for all of her college the first year for her schooling and her rent and all that stuff. So it's not a thing where I'm trying to avoid it. I think I can afford the $200 a month, and I wish I would have put some of that money through the court and got it if I knew there was a balance and got it taken care of.
Sure.
That's really it,
All right.
Your Honor.
Okay. All right. Well, obviously if you're behind when a child turns 18, the amount that you're behind doesn't go away. I
Sure.
understand your situation. Do then is we'll indicate that you are to make monthly payments of $200.
Sure.
I'm going to set this out a few months just to make sure that that's happening.
Okay.
I'll set you out to July 10th, but I will indicate that if you've made your regularly monthly payments, then that hearing could be removed and you wouldn't have to appear. Okay.
Excellent.
All right. Thank you, sir.
Your
I'll
Honor.
be on that matter, President.
Yeah.
All right. You are Mr. McMurphy.
Yes, I am.
Thank you. In front of the court, what is the status of this matter?
Your Honor, the defendant has a monthly support obligation of $410. Current balance on the account is $2,060.89. Last payment received was in March of 24, which was an involuntary payment in the amount of $173. Prior to that, we received payment in November of 2023 in the amount of $426.20.
Thank you. Mr. McMurphy, what would you like to say?
I am waiting to go back to work right now. And I do believe it is on the 16th of this month that I go back.
All right.
I work for M&M Excavating, which is only for the seasonal. So during the winter hours, I get laid off.
All right. Do you collect any unemployment when you're laid off?
I tried to, but I kept forgetting to call.
All right. Well, that's not really a valid reason to decide you're going to take months off paying. So you got to do better moving forward in the future, certainly.
Yeah.
As well as perhaps budget yourself to know that you're not going to have as much income coming in the other months.
Yep.
So that you don't find yourself in this situation.
Yeah. I agree with you.
So you think when you get back to work, you can start making some good payments, sir?
Absolutely. I like to have it auto deducted out of my checking account, out of my bank, out of my checks. So.
All right. So have you had an income withholding order before or not?
Nope.
Okay. All right. So in front of the court, we'll look into establishing an income withholding order. We're going to adjourn your matter to May 22nd to get the information about you being back, as well as check on that income withholding order and payments. If you start to get paychecks and the income withholding order is not in place yet, you do need to make payments to the front of the court on your own. You understand, sir?
Yes, I do.
All right. Thank you. We'll see you back here on May 22nd.
All right. Have a good day.
I'm here, Your Honor.
All right. Thank you. Mr. Owens is present. In front of the court, what is the status of this matter?
Your Honor, this matter was adjourned from March 20th due to some audio issues experienced by the defendant. She has a monthly support obligation of $216 and current balance on the account is $11,906.94. She did make a payment this month in the amount of $100, but prior to that, last payment received was in January of 24 and the amount of $200.
Thank you. Mr. Owens, any questions or anything that you would like to say?
Yes, Your Honor. We've continually gone through this over and over. It's a continued pattern, and I don't understand why it continues to be an issue.
All right, thank you, sir. All right, well, given Ms. Owens' failure to appear, I will recommend the issuance of a bench warrant. Recommend a bond amount of $4,500 plus $100 in costs. All right, Mr. Owens, you're all set.
Thank you, Your Honor.
I'm present, sir. Sean Stidham, and I have two cases.
Yes, sir. All right, so as to this matter in front of the court, what is the status of this file?
Your Honor, he had court on February 14th, and we adjourned to monitor income withholding and his employment status. He has a support obligation of $124. and has a current balance on his account of $1,223.13. He was ordered to pay until the income withholding did take effect. However, we have not received any payments. Last payment received was an involuntary payment this month in the amount of $297.18. And prior to that, another involuntary payment in March of $23.78. And the last payment he made was in September of 23 in the amount of $174.20.
Thank you. All right, sir, what would you like to say regarding this matter?
I'm not working much, and I had to catch up on rent and bills as part of the reason why. And I've just started the job in end of January, and I was that far behind in rent for both cases, honestly. So it's part of my issue, and I have to pay out so much for my truck to be able to go back and forth to work. So I'm having a little trouble, but like I've caught up on rent. I'm trying to get it to the other side now. I don't even talk to my kids.
All right, we don't have a very good connection at the moment, so some of your words are breaking up. What I got from that is you're not working as many hours as you anticipated. Is that correct?
Essentially, yes. I'm not working as many hours, and me being behind on rent before this, before I got the job, I had to catch up on rent also. So I actually have a place to stay.
Okay. For the court, so
because
you know where we're at withholding process?
I don't know if it's been started yet, but we have not received any money from income withholding.
And do you know which employer that's for?
Could confirm the name of his employer. We'll make sure everything's good to go.
All right, who's your employer, sir?
Herb Cannabis Dispensary in New Buffalo.
Do you anticipate hours increasing here?
No, honestly. We have over 200 employees for not a very big store. Coming up soon, I'm probably going to start looking for more work because one, I want to get.
Is there a reason you can't work a full-time job, sir?
That's why I said I was about to go look for another job. I just use this for the moment to catch up on rent, really.
All right, what are you using to catch up on your support?
At this moment, since I just got caught up on rent, I was going to start making payments on it. If it's not coming out of my check, I might as well just make the payments.
That's good in theory, but you've said that before that you would make some payments, and it looks like you haven't. I'm going to call the other case so we can kind of combine the two. I'm going to call the other Stidham versus Stidham matter, file number 19-17697DM. For the court, what's the status of this file?
This was also adjourned from February 14th to monitor employment and income withholding. He was ordered to make payments until the income withholding took effect. We have not received any. Monthly support obligation on this case is $95 a month. Current balance is $1,101.93. The last payment we received was an involuntary payment in April in the amount of $191.82. Previous to that was March, also involuntary in the amount of $18.22. And the last payment he made voluntarily was in September of 23 in the amount of $123.74.
All right, thank you. All right, sir, what is your monthly rent obligation?
$1,100 a month.
Okay, what other bills are you paying monthly?
That includes all of it at the moment.
Do you have a car payment?
No, sir, I own that.
All right. Car insurance?
It is actually, that is one of the things I did pay off 6 months. It is good. I don't have to pay that anymore. It's like it was one of the things that helped me set up to get into a better standpoint to be able to child support easier.
All right, I'm gonna move your matter out to about a month to see if you make April.
I'm sorry, sir. You broke up on me.
All right, we're gonna adjourn your case to May. All right, I don't know who's got feedback going on, but I think it might be you, Mr. Is everyone else?
I don't have the greatest service. I will admit to that.
All right, I'm adjourning you to May 1st. you need to make this a priority. You've certainly prioritized other bills. Got income coming in, so there'd be an expectation that you are making on both of these funds. If you haven't made an April payment when we come here in May, it is likely that I would recommend a finding of contempt.
Okay. I have to make sure I understood that because you did break up in the process. May 1st, correct?
Yes, sir.
And if I don't make the April payment only, or do I have to pay more than just April? I got to know so I understand this.
I'm saying if you come into court and you've made 2 payments, you can expect a finding of contempt.
Sorry, it keeps muting me too for some reason. You said if I don't make any payments, it's contempt?
Yes, that would be a likely outcome.
Okay. So if I can go ahead and pay April, I'd be in a more better standpoint for it?
Well, if you want to be in your best standpoint, you would get caught up. But yes, you need to show some effort on making your payments here.
Okay. Unfortunately, I don't think I can pay $3,500, sir. Otherwise, I would.
All right. Well, you can also seek out additional employment and find some other income if you're not working full time. We'll see you back here May 1st. Thank you.
Thank you.
All right. We have Mr. Mogenberg present. In front of the court, what is the status of this matter?
Your Honor, the defendant has a monthly obligation of $32 a month, but had signed a stipulated order with us in December of 2023, agreeing to pay $49 a month, $32 for the regular obligation, and then $17 towards his arrears. He has not complied with that step. He has a current balance on the account of $828.50. The last payment we received was in March of 24 in the amount of $29.36. Previous to that, it was December of 23 in the amount of $250.
Thank you. Mr. Mogenberg, what would you like to say?
Well, I mean, I got arrested for the lack of payment. It was like $700 and something that they took. But the whole reason why I didn't make a payment was because my mother passed away in the start of January, and I came in and I made a payment. I didn't know. I guess it went to one of my other case, but I made a little over $100 and something in payment in mid-March, and the simple fact that that Ms. Fisher has not had any contact with her daughter since the start of December. I need to get in there and I need to get something filed for to have the review looked or the report looked at. But there's really no excuse other than the fact that my mother passed away and I'd kind of been dealing with that. And most of what I do for labor is during the summer, but I'm working now. I'm actually at a job site right now. It's just day labor this week, but I'm hoping to get brought on full time and to be doing roofing, but I won't be getting behind anymore, and I will be getting things set up to have a support review done too, or custody review.
All right. Well, from the court's perspective, in December, it sounds like you entered into a stipulation, essentially to get yourself out of jail and findings of contempt, and you have not complied with that. I understand that there might be some issues regarding where the child is at, but that is something that you have to take care of paperwork wise. And until there's a change, you're obligated to be making that payment that you agreed to of at least $49 a month on this matter. When do you intend to make it? When do you intend to make a payment on this matter, sir?
I get paid on Friday, so either depending on the time of day on Friday or on Monday.
And how much can you pay?
At least $100.
All right, I'm going to adjourn your case to, we'll adjourn it to May 1st. And I'll indicate that you are to have made a payment of at least $100 prior to that court date.
Thank you.
Any questions, sir?
Not at this time. I'll ask a friend of the court when I make the payment.
All right. Thank you.
Thanks.
I'm present, Your Honor.
I'm present, Your Honor.
Thank you. We do have both parties present. In front of the court, what's the status of this matter?
Your Honor, this matter was adjourned from February 21st to monitor income withholding employment status. The defendant has a support obligation of $695. Current balance on the account is $7,431.38. We just received a payment this month in the amount of $100. Previous to that, we received $200 in March, and prior to that, December of 23, in the amount of $700. We would like to add an additional $150 on his order of arrears, increasing his monthly obligation to $845.
Thank you. Mr. Martinez, what would you like to say regarding this matter?
That I am doing my best to pay my monthly child support. I am not making the same income as what they got me down. That's momentarily. I am not making what I was used to. I'm still looking for work. I am working here and there, picking up jobs, but it's not a consistent thing momentarily. But I'm doing everything that I can.
Are you working full time?
No, I am looking for full-time work, but I'm still looking, and I am doing part-time work, jobs here and there. So I am bringing in income while I'm still looking for a full-time job.
So for the those payments, are those payments he's making, or are those income withholding?
Those are payments he has made.
Okay, all right, thank you. All right, Mr. Martinez, anything else you'd like to say?
No, that I'm doing my best, and I'm gonna continue to do my best so I can catch up.
Do you rent a residence, own, or live with somebody?
We own a home, and I'm married.
Okay. Do you make a mortgage payment?
Yes.
What is your house payment?
$900 a month.
Do you have equity in your home?
I do not believe so. No.
How long have you owned your home?
I got it, I believe, 3 years ago. 4 years ago, I believe. Something like that.
Okay. Do you know what your loan balance is?
I did not know that. My wife has all that information.
All right. Have you taken any new loans out or mortgages out on the house since you first purchased it?
I do not believe so.
Okay. Do you think the house's value has gone up since you first purchased it?
Honestly, sir, I have no idea.
Well, the housing market is very strong, so it's likely it has gone up. And if you've been paying on it for 3 years, there's certainly got to be some equity available to you. So you have a potential asset to address this issue. Anything else you'd like to say, sir?
No. Yeah, I have a question. Because you guys got me down for paying over $600 to $800 a month, and I don't have a job bringing that in. Not once have I had an issue. Not once have I had an issue of paying child support until I lost my job. I've been current, and now that I'm falling behind, you guys are not trying to work with me. You guys are trying to make me pay more.
Your balance continues to rise, and support is not based on the number of hours necessarily that you're working. You're expected to be able to maintain full-time employment unless there's a reason why you can't. So if a person is underemployed, it doesn't mean you get to lower your support amount. If you think there should be a change, you have the right to file a motion, and we can decide if there should be a change in the amount. But simply being underemployed is not sufficient to lower the support obligation payment.
All right, so I will just have to write a motion in. No, there's no problem, Your Honor. I appreciate it. I will continue to do my best, and I will try to do another payment when I get another job.
Ms. Canterbury, do you have anything that you'd like to say or any questions, ma'am?
No, Your Honor.
All right, I'm going to give Mr. Martinez an opportunity to show that he can make some more payments on this matter, as well as hear his update regarding employment. We will adjourn this matter to June 12th. Mr. Martinez, you've got a large balance that continues to grow. Sounds like there's probably ways for you to attack this balance that you have. You've got assets available to you. So we'll come back on June 12th and see what you have done, what attempts you have made to get yourself on track here and address the balance in this matter. Any questions, sir?
Yeah, I don't understand what you mean. I have assets. What assets do I have? Because if I do, then I can take a look into it. Because I have no idea what you're speaking on.
I would guess that you certainly have equity in your home.
So I need to look to see this equity in home. Even if I don't own it, even if me and my wife own it.
Testimony to me, sir, was that you own a house.
Right. So my question to you is, if I own the home, I can go and look into equity into the house. That's what you're saying?
I'm saying, based on what you told me, it appears that you do have equity potentially in a home, which might be a way for you to get this balance taken care of and not have to find yourself in. Okay.
Okay, then I can definitely take a look at it. I did not know that. Appreciate it.
All right. You're welcome. We'll see you back here on June 12th. Thank you. You have
Thank
either
you.
party on that matter, Preston?
Yes, Your Honor.
Yes.
All right. Both parties are present. In front of the court, what's the status of this matter?
Your Honor, the defendant has a support obligation of $553. Current balance is $2,601.91. He did make a payment this month in the amount of $200, but previous to that was December of 23 and the amount of $184.09. He did recently inform me of a new employer. We do have the income withholding process started, and he is aware of making the payments himself until that income withholding takes effect.
Thank you. Mr. Nantel, anything that you would like to say?
Yeah, so over the winter, I worked at FedEx, and I had informed friend of the court about my employment there, which I believe they sent papers over, but my employer never deducted my child support out of my pay. So I didn't know that they weren't taking it out until like a couple months ago.
All right. And then what's your employment situation now?
The full time with Reith Riley.
And do you understand that until it's coming out of your check, you need to make payments when you get paid?
Yes, sir.
Ms. Cruz, anything that you would like to say or any questions that you have?
No, sir.
All right. Well, given that information, as well as Mr. Nantel's understanding that until that money comes out, an income withholding order, he needs to make sure he's making a payment. So, sir, you got to closely monitor your paychecks. You should be able to quickly tell whether or not money's coming out for this or not. And if it's not, you need to make a payment. I'm going to adjourn your matter to June 12th to see where we're at with the income withholding order, as well as payments that you've made on your own. Any questions, sir?
No, sir. I'll have it all paid off next month here.
All right. Thank you. We'll see you back here June 12th.
All right.
You have either party on that matter present?
Yes, I'm here as well.
Your Honor, on behalf of the defendant.
All right. In front of the court, what is the status? Well, this is an objection to a support recommendation. Is that correct?
Yes.
Okay. All right. So, Ms. Eagleston, this is your motion, your objection to a child support recommendation. Is that correct?
That's correct.
All right. And what would you like to say regarding your objection, ma'am?
My objections, the defendant stated back when child support was being determined that he was under economic hardship, that he couldn't afford anything, he was on unemployment. The child support order then got backdated to the original date of 8/14 of 20. So his child support was reduced from just a little over $600 a month down to just under $200 a month, which he was not paying in full all the time. During this economic hardship time frame, he reduced his parenting time for 6 months because he was taking vacations. He also bought a house 4 months after stating he was under economic hardship. He got married as well. Just lots of things that don't really add up to being under economic hardship. It's just not adding up. And then he stated in the last hearing that he's not even held responsible for the house. And while that may be true now, because him and his wife had gotten divorced, he is on the warranty deed and the mortgage note, which is the promissory note signed by the borrowers. And he's stating that it wasn't his house. He wasn't liable for the payments on it. He was even on the water bill.
All right, so as to the calculation in the most recent recommendation, what are your objections to the calculation?
Just because it's the original one based off of his potential and what he had done before, his income potential from before, the child support went from the 600 and it dropped drastically to the 200, and then now it's only at 400. And I just believe that maybe there isn't, I think there may be some hiding of things here going on. He does work for his mother, who inherited the company he works for. They both have been in trouble for lying, for fraud, unemployment. Jeremy has been in trouble with unemployment for fraud. I just am concerned about the legitimacy of these documents. I don't know if he lied to the house company or if he lied to friend of court, but I just don't feel like these numbers are adding up very well after claiming that he was under economic hardship and suddenly he was able to do many, many big things.
Friend of the court, how was Mr. Dudd's income calculated?
His income was calculated at $15 an hour by 40 hours a week. He did provide a questionnaire, pay stubs, and tax information.
Thank you. Ms. Kern, anything that you'd like to say on this issue?
Briefly, Your Honor, there's a mischaracterization of the facts. Ms. Eggleston's objections there is no legal basis for them. It's just her supposition of what she thinks she should be awarded or that Mr. Dudd is making. Respectfully, Your Honor, we are asking her objection to be dismissed and that it enter as ordered.
All right, thank you. All right, well, given the information provided, front of the court indicates they calculated Mr. Dudd's income based off of the information provided to them. The plaintiff is suspect that accurate information was provided, but the court is without any proof that there is other income to address regarding Mr. Dudd. Therefore, I will deny the objection to the child support recommendation.
Thank you, Your Honor.
All right, thank you everyone for appearing. That does conclude the matter.
Thank you.
Thank you.
Yes, I'm Sarah, Your Honor.
Thank you.
Get my visual camera real quick. I'm here. Can you hear me?
All right, sir. I can hear you muttering, but you're not coming through very clear. So I don't know if you either need to get closer to a microphone or speak louder.
All right, this is Vincent. I'm here.
All right, thank you. All right, and Ms. Foster, this is your motion regarding pairing time. Is that correct?
Yes, I filed the motions based off of Vincent and my agreement. We spoke and then I went ahead and filed the motions after we had talked about them.
All right, so the two of you are in agreement to making some changes?
Yes.
All right, and can you outline what those changes are?
Sure. So the changes are that our daughter will be primarily residing with Vincent. So we're agreeing that primary custody of Brianna would be moved to him. And we would continue with joint legal together. And we are agreeing that the child support would be reduced 100 to 600 based off of her living up with him. And Owen would continue to reside with me. And the parenting time, we've agreed on the up to 2 weekends a month. And we've agreed that it will remain in Pennsylvania, which is how we had it set up before, that all the visitation will occur here in Pennsylvania, where Owen and I reside.
Okay. It looks like you have an agreement regarding Christmas and Thanksgiving also. Is that correct?
We do. Yeah, we've had that since 2012 when we were divorced.
Okay. All right. And Mr. Barbagallo, are you in agreement with those changes?
I am. Yes.
All right. So I'm going to put you each under oath separately and just put that on the record formally. Ma'am, I will start with you. Could you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
All right, ma'am. And is it correct that you're asking the court to change the current custody and grant Mr. Barbagallo the primary custody of Brianna?
Yes.
And you would continue to share joint legal custody, is that correct?
Yes, that's correct.
You're also in agreement to change the child support from $1,200 a month to $600 a month, is that correct?
Yes, that's correct.
And then for parenting time, you would agree that you would have up to 2 weekends per month to take place in Pennsylvania, and that you would continue to follow holiday parenting time as you previously have. Is that correct?
Yes, that's correct.
And do you feel this agreement is in the best interest of your children?
Yes.
Thank you. Mr. Barbagallo, would you please raise your right hand? And do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right. And sir, are you also in agreement to change the primary custody of Brianna to yourself, but the parties would continue to share joint legal custody? Is that correct?
Yes, it is.
You're also in agreement that child support would be reduced from $1,200 a month to $600 a month?
Yes, that's correct.
And you agree to the parenting time would be up to 2 weekends per month in the state of Pennsylvania, and you would continue to do holidays as you previously have. Is that correct?
That's correct.
And do you feel this is in the best interest of the children?
Yes, I do.
All right, thank you. Do either of you have any other questions?
No.
We do have it. I do have one question. We do have it set. Just the alternating parenting time also does take place here in Pennsylvania as far as the Thanksgiving but Brianna, of course, if she's residing with Vince, I mean, can remain up there for the holidays. So if that's what he chooses.
All right. Okay. All right. We will prepare an order regarding the parties' agreement, and that will be sent to the parties. Thank you.
Thank you.
We have the parties on that matter present.
Yes, sir.
All right. Mr. Butts is present. Is Ms. Dalbenspec present? All right. Again, I'm having trouble hearing you, ma'am, so I don't know if you need to either speak louder or get closer to a microphone. All right, Mr. Butts, this is your motion regarding parenting time. Is that correct?
Yes, sir.
And what are you seeking to change?
Parenting time be not at her house, but also at my house too. I know he's young and it's comfortable for him out there, but he's got to be able to know me at my house where it's convenient for me. You know, I'm working. It would be more convenient. I don't want to fight and argue. We haven't been fighting and arguing, so I filled out the motion, so there is no fighting and arguing. And I would just like more parenting time. I haven't been consistent, even on the child support. I haven't tried to really get too much into his life because of me being inconsistent. Now that I have a job, I'm working at A&L Monday through Saturday. I would like to be able to see my son get to have a relationship and know him. And I would like that to be at my house also, or even some kind of area in Gaylord that's convenient for her and I, you know, just more than over there.
All right, so looking at the paperwork, it looks like the order went into place in November 2022. That order gave the parties joint legal custody, gave the mother the physical custody, and indicated parenting time was as the parties agree. A parent has a right to a specific parenting time schedule if they wish to have one, and it sounds like Mr. Butts is seeking to have a specific parenting time schedule. Ms. Dalbenspec, as to his request regarding a change in parenting time, are you opposed to his request or in agreement?
I'm in agreement, sir.
All right. Have the two of you discussed any specific terms of parenting time or not?
As of right now.
Okay.
I'm sorry.
Well, there's a couple ways we could do this. The two of you could we could adjourn this matter out. The two of you could have a conversation to see if you can reach an agreement. We can also refer this matter to mediation, and then you can have someone help the two of you talk it through and see if you can reach an agreement. What are your thoughts, Mr. Butts?
Whatever, Ms. Dalbenspec. I have no problems either way. I mean, I have not sat down and tried to talk to her. This is kind of a heads up, like bomb to her. This is all news. I haven't been. I'm ready. I think we could adjourn it and let me and Ms. Dalbenspec figure it out, unless she would like to have other matters.
Okay, Ms. Dalbenspec, do you want to try to see if the two of you can work it out, or would you like to try and meet with the mediator?
we'll try it by ourselves for now, and if it doesn't work out, then I guess it'll go to mediation.
Sure, and that's certainly an option, is you guys can try it first. If it works, great. If it doesn't, but you still think, maybe perhaps the mediator would work, then you can do that. And if there is still no resolution, then the court would just set the matter for an evidentiary hearing and the parties can provide testimony and witnesses. So I'm going to adjourn your case to, well, I'm going to let front of the court pick the date, but it'll be sometime in 30 to 60 days. And then in the meantime, if the two of you can have some discussions and see if you can reach an agreement. Yes, Mr. Butts.
I also got to update the front of the court after this matter too. I'm sorry, I just dawned on me about me having my job.
Okay. If you want to give them a call after we get off of here, you can, and pass that information along. Okay.
Yes, sir.
All right. So we're going to send you both a new date. In the meantime, then, if the two of you can discuss the matter to see if you can reach an agreement. If you find that you don't reach an agreement and you want the matter referred to mediation, you can also call the friend of the court and we can prepare that paperwork too. Any questions, Mr. Butts?
No, sir. Thank you.
Ms. Spec, any questions?
No, sir. Thank you very much.
All right. I appreciate the two of you trying to work it out together. And it's always certainly better when the parents can try and work together to figure out what is the best schedule for their child. Thank you.
Thank you. Have a good day.
Do we have parties on that matter present?
Yes, Your Honor.
All right. Is Mr. Wood present? Don't see Mr. Wood in the court's Zoom room.
Yeah, I'm here.
All right, under a different name, that's no problem, sir. Thank you for signing in. Mr. Wood, this is your motion regarding support, is that correct?
Correct.
You are asking that support be set at 0, is that correct?
Correct.
Ms. Dewey, are you in agreement with that or disagreement?
Yeah, I'm totally fine with that. We've always agreed if we split up, we would never make each other pay child support.
All right, is there any assistance that is received by either party or for the children or for the child?
The only thing I get right now is Medicaid for my daughters.
All right. So given that you do receive Medicaid, we cannot completely go down to 0. Is that correct, front of the court?
That is correct.
We could deviate to just the medical?
Yes.
All right. So Ms. Dewey, the two of you have joint custody. Is that correct?
Yes. And just for the record, my ex-husband, they kind of did the same thing with him where they only made him pay like the medical, which was $20 a month just to cover the medical thing.
All right. And ma'am, you are willing to deviate down then to just the medical?
Yeah, that's fine.
And you're not, and you're doing that, making that decision voluntarily?
Yes.
And you feel that you adequately have the ability to care for the child without any funds from Mr. Wood?
Yes, that's correct.
All right, well, given the parties' agreement then, the court would grant the motion and the child support should reflect only the medical and it would deviate down to 0 for the remaining child support calculation. Any questions, Mr. Wood?
No, I agree with everything.
Okay, Ms. Dewey, any questions?
No, thank you.
All right, they will prepare that new support order. Thank you.
Thank you. Have a good day.
Ms. Churchill, can you hear me okay?
Yes, Your Honor.
All right, and Mr. Backlund, if you could please place your appearance on the record.
Certainly, Your Honor. Zach Backlund on behalf of the defendant, Joshua Churchill. We just filed our appearance yesterday, Your Honor, so it may not be in the court's file yet.
All right, thank you. And we are here today on a motion regarding hearing time filed by Mr. Churchill. I've had involvement with the parties in the past. I've represented Mr. Churchill, and there was a matter that involved also Mr. Churchill that I represented Mr. Churchill on. I believe due to that representation, that my continued hearing of these matters would create an appearance of impropriety. So I'm going to sign an order of disqualification of myself. The matter will be reassigned. I don't know if they'll reassign it to a referee or simply just set the matter directly in front of the judge, which is probably what I think is likely. But I think given my history with the parties, that is the appropriate step. Do you have any questions regarding that, Ms. Churchill?
I do not, Your Honor.
Mr. Backlund, any questions?
No, Your Honor. Thank you.
All right, so we'll take care of that paperwork. I believe the court then will get that assigned and get a court date set and out to the parties.
Thank you.
All right.
Thank you.
Ms. Pfizer, could you please unmute? Let me know if you can hear me okay.
Yes, I can.
And Mr. Beebe, can you hear me okay? All right, I do need you to unmute also.
Say that I was. Okay. Yes, I can hear you.
All right. Thank you. So the parties are present. I do have a document that was sent to the court, labeled parenting time agreement, indicating that the parties have reached an agreement. Is that correct, Ms. Pfizer?
That is correct.
All right. So, ma'am, I'm going to start with you then. Would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And ma'am, are you asking that the court adopt this parenting time agreement that the two of you signed, it looks like on March 13th? Yes, on March 13th of this year?
Yes.
And essentially that is changing the parenting time for Mr. Beebe, is that correct?
That is correct.
So the two of you would share joint legal custody as well as joint physical custody with a week on, week off parenting time schedule, is that correct?
Correct.
And are you asking the court to adopt then the other agreements that are in that document?
Yes.
In particular, are you asking that child support deviate to 0, so be changed to 0?
After what he owes, I'm asking that nothing past this point. So anything that's back child support, like I still would like him to pay. And then after that, I am good with it being suspended until further notice.
All right, so April's not over. So what is your thoughts as far as an April payment? April?
No, that can be suspended. I do not need an April payment. As long as like back is done, we're good to go.
All right, so make the child support 0 effective April 1st of this year.
Correct.
And then you're also asking that the court adopt the other terms that are in there regarding insurance, as well as then activities and things like that for the children that are addressed in that parenting time agreement.
Yes.
And do you believe this is in the best interest of your child?
I believe this is in the best interest of Cameron, yes.
Thank you. And are you doing this voluntarily, ma'am?
Yes.
Thank you. Mr. Beebe, would you raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And sir, are you also asking that the court adopt this parenting time agreement that the two of you signed on March 13th of this year?
Yes, I am.
And you understand that would change the physical custody to joint physical custody with the two of you having a week on, week off parenting time schedule?
Yes, I do.
Then you would continue to alternate holidays per your original agreement, is that correct?
Yes.
And you're also in agreement regarding the paying support through March of this year, but then it becoming $0 effective April 1st, is that correct?
Yes, that's correct.
It looks like you were also to apply for health insurance, is that correct?
Yes, I have a waiting period for my new job. Once that becomes available to me, I will be applying for that.
And you agree to all of the other terms in that parenting time agreement, is that correct?
Yes, I do.
And do you feel this is in the best interest of your child?
Absolutely.
And are you doing this voluntarily?
Yes, I am.
All right, the court then would adopt the parenting time agreement prepared by the parties and signed on March 13th. One of the more important provisions, obviously, the parties would then begin to share joint custody with a week on, week off exchange based on the terms in that agreement. Child support would be $0 effective April 1st of 2024. Any questions, Mr. Beebe?
No, Your Honor.
Ms. Pfizer, any questions?
Nope.
Friend of the court, anything you think we need to address?
No, thank you.
All right, thank you both for appearing. It does conclude the matter. You will get a copy of the court's order. Thank you.
Thank you.
Mr. Crowderfield, can you hear me okay? And Mr. Crowderfield, can you hear me okay?
Yes.
All right, we're here today. This is a motion that you filed. Is that correct, Ms. Crowderfield?
Yes.
And what are you seeking to change, ma'am?
I'm asking that I can carry the insurance on Zoe instead. My insurance is a lot cheaper than Hunter's. It would only be $119 per payday every 2 weeks. I used to work at the company that Hunter works for, and I was paying $71 per week just for myself. I feel like it would benefit everyone to do that. I'm also I'm the one that takes her to her appointments and does all that stuff. So it would just be easier in a sense for me to carry the insurance on her.
All right, Mr. Crowderfield, what is your position on that request?
I mean, it might be cheaper, but it doesn't affect her. I'm the one that pays for Zoe's insurance. And as far as taking Zoe to her appointments, there's only been the last 2 appointments that I haven't made it to. I've been to every single one of her appointments except for those 2. And I didn't really think that I was going to be thrown in the face that I didn't make it to those 2. But as far as insurance-wise goes, yeah, it'd be cheaper, but I'm the one that pays for the insurance, not her.
All right, it looks like there is a prior support order that indicated that Mr. Crowderfield would provide the healthcare coverage. So, sir, are you objecting then to her providing the insurance?
Yes, because I already have the insurance established with Zoe, and I gave Haley the information she needed for her insurance.
All right, and Ms. Crowderfield, anything else you want to say on this matter?
When it came to him giving me the insurance card, it took like a few months for me to finally get it from him when I finally had to take her to an appointment. Also, all her previous bills from the birth, I'm the only one paying those currently. So honestly, it would just be easier since I'm majority of the time the one taking care of all the bills and taking her to the appointments for me to carry the insurance on her. And I'm helping, I'm paying him child support. Most of that is for the insurance.
Okay, well, the court has to look at what is the current situation as far as is there proper cause or change of circumstances to change support. There was a support order, it appears just recently. That particular order provided that Mr. Crowderfield would pay the health care coverage. Well, I think it would be sensible to have somebody who can provide something at a cheaper rate provided based on what the current order is, and that the lack of agreement between the parties, I would deny the motion for the change. So Ms. Crowderfield, if you end up providing coverage, you should let the front of the court know, because that could then become a factor in any changes to the child support.
Okay, because my job told me if there was an order, they could obviously put her on there, but if I have to wait until the next enrollment season, I will do that.
Okay. All right, any questions, ma'am?
Nope.
All right, Mr. Crowderfield, any questions?
No.
All right, thank you both for appearing. That does conclude your matter.
Thank you.